Leniency programs are the most effective and important investigative tool in the arsenal of cartel enforcers. But in recent years, there's been a downturn, both in self-reporting and with respect to seeking leniency even after an investigation begins by cooperating with an authority, admitting to guilt, and receiving a sentencing reduction. This downturn is not simply a result of cartel enforcement being cyclical. It's been over a course of a number of years. Commentators first recognized that there was a downturn with respect to leniency applications a number of years ago, recognizing that there's a delicate balance between the costs and benefits of admitting to guilt and being subject to sanctions in multiple jurisdictions. There has also now been a downturn with respect to self-reporting. Fewer and fewer companies are coming forward and self-reporting international cartel activity. There have been great success in a number of jurisdictions, for example in Latin America, where there have been monumental self-reporting in domestic cartel cases, but overall with respect to international cartels, there has been a downturn. I want to applaud the OECD and its members for acknowledging that there are challenges and that there is a need to examine why it is that there is a downturn with respect to the use of leniency programs. The proliferation of private damage actions is often pointed to as a reason behind the downturn. And in fact, there has been greater and greater costs associated with self-reporting and seeking leniency as a result of private damage actions, not just in the U.S., but around the world. It's up to competition authorities to develop policies and to promote legislation that ensures that companies that come forward and report wrongdoing are not worse off than companies that fail to cooperate. Enforcers cannot rely upon the private bar to ensure that the incentives for self-reporting remain intact. The private bar has an interest in protecting the rights of their clients, whereas the competition authorities have to consider the institutional interests of promoting self-reporting. So legislation and policies that limit the scope of private damage exposure, such as by limiting joint and several liability for companies that come in and self-report conduct, or limiting even the scope of damages to just direct damages as opposed to indirect damages, is a way of continuing to promote the use of leniency programs. Similarly, criminal sanctions has been pointed to as a potential reason why leniency programs have become less attractive. The threat of criminal sanctions can be both the single greatest incentive for self-reporting and also, or alternatively, the greatest disincentive to self-reporting, depending on whether or not a leniency applicant can predict with relative certainty whether or not self-reporting will result in protection not just from administrative sanctions, but for criminal sanctions as well. Now, there can be a legitimate debate about whether or not criminal sanctions are appropriate for sanctioning cartel activity, or whether or not criminal sanctions are working. But there shouldn't be a debate as to whether or not criminal sanctions, when applied and when covered by a leniency program, do create a great incentive for self-reporting. Now, I would suggest that viewers look to countries like Chile and Mexico, who have dealt with this issue of ensuring that leniency applicants are protected by criminal sanctions very deftly. The legislation that was introduced in those jurisdictions and promoted by the competition authorities has ensured that criminal sanctions there has become a great incentive to self-reporting in those jurisdictions, and their leniency programs are flourishing because of it. The last observation I wanted to make is with respect to the importance of maintaining confidence in the good faith application of leniency programs. The mantra of all competition authorities needs to be that when a company comes in and self-reports conduct, that the authority is going to tilt the program in favor of ensuring that a company is admitted into the program. Never playing gotcha with leniency applicants. In addition, the golden rule of leniency programs is to ensure that a leniency applicant is never worse off for having self-reported, never in a worse position than a company that didn't cooperate. Because if there's a crisis of confidence in the application of the leniency program, that will do far more damage to the leniency program than private enforcement or any of the other potential disincentives could ever cause in terms of harm to a leniency program. Thank you very much.